Very good afternoon, everybody. Good afternoon to you all. Before starting with this afternoon's sessions, I would just like to say that we have interpretation into Slovenian in channel 7.
In channel number 7. Okay. Bien.
So, I would like to extend the warmest of welcomes, of course, to Ms. Tina Braseli, Her Excellency, the head of delegation for the Republic of Slovenia. We are delighted to receive such a large delegation. According to what I've been told, they are also very highly qualified in terms of specialism and expertise in responding to the questions of the committee. The head of delegation was telling me that they were impatiently awaiting and somewhat fearfully awaiting the committee's questions because they know that the committee is very rigorous. And I told her not to worry. I said that our committee is very well qualified and that they would ask very appropriate questions so that we could have the best of dialogues possible. And that is how we will proceed. We are looking at the third periodic report of Slovenia. We are in meeting number 3246 of the Human Rights Committee. We have the report presented by the state, and we also have the responses and the list of issues which arrived in time, and so they have been translated into the committee's different working languages. So I would also like to thank the State Party for cooperating with us in this respect. I'll explain how we will proceed in this afternoon's session. We will look at the first 10 issues. So the first 10 topics on the list of issues. I will give the floor to the head of delegation so that she may give her opening statement. And then following on from that, colleagues in the committee will ask questions, express their concerns, ask for clarification on topics 1 to 10. Then we will have a short break, and the State Party will have the time to prepare responses using this room or the room just next door so that they can work comfortably. Then the State Party will respond to the questions, and then after that, colleagues will be able to ask follow-up questions. We always say to state parties that sometimes when they cannot provide the information in the session at that time, they can provide extra information in the 48 hours following the dialogue, and they can do so in writing. Excellent. I believe that everything is clear, so I will give the floor to Her Excellency Ms. Tina Braseli so that she may give her opening statement. You have the floor, Madam.
Thank you very much for your kind invitation. Good afternoon, Mr. Chairman, members of committee, ladies and gentlemen. It is a great honor to present, as head of the Slovenian delegation, the third periodic report of the Republic of Slovenia on the measures for the fulfillment of human rights ensuing from the International Covenant on Civil and Political Rights. Let me first express our regret for submitting the report rather late. In 2013, Slovenia fulfilled a series of reporting obligations towards treaty bodies. In addition to the report presented today, our country submitted the reports pursuant to the Convention on the Elimination of All Forms of Discrimination against Women, the International Convention on the Elimination of All Forms of Racial Discrimination, and the Convention on the Rights of Persons with Disabilities, as well as a new Common Core document. I can assure you that Slovenia remains committed to respecting its obligations to the Human Rights Committee as the body central to implementing the provisions of the Covenant on Civil and Political Rights. At the outset, allow me to present the Slovenian delegation. It's rather large, this is true, and the members of the delegation are Mr. Peter Paulin, Mr. Jernej Kosel and Mr. Robert Golubinek from the Ministry of Justice, Ms. Ružica Boškić and Ms. Jana Lovšin from the Ministry of Labor, Family, Social Affairs and Equal Opportunities, Ms. Sonja Trančar from the Ministry of Culture, Mr. Aleš Ojsteršek and Ms. Mia Javornik from the Ministry of Education, Science and Sport, Mr. Sandi Čurin, Ms. Alenka Snoj and Ms. Sabina Hrovatin from the Ministry of the Interior, Mr. Peter Skerbiš and Mr. Anton Toni Klančnik from the Police, Ms. Dragica Iskrenović from the Ministry of the Environment and Spatial Planning, Ms. Vesna Kalčić and Ms. Tjaša Herman from the Office for National Minorities, and Ms. Alenka Markov from the Ministry of Foreign Affairs. And of course me, Tina Brecelj, Deputy Minister of Justice. Mr. Chairman, the third periodic report of the Republic of Slovenia spans from the period from the consideration of the preceding report in 2005 to May 2014. Relevant information is also included in the new Common Core document submitted in October 2014, and the replies to the list of issues submitted last November. During the 2 years following the submission of the report, several significant political, legislative, and other changes occurred in Slovenia with regard to the protection and implementation of rights pursuant to the Covenant. The 2014 parliamentary election substantially improved the representation of women in politics. Today, the percentage of women in the National Assembly is 35.6%, while 50% of ministerial posts are occupied by women. After years of economic and financial crisis, which severely affected Slovenia, 2014 showed first signs of economic recovery. Growth continued in the following year, and at the proposal of the government, at the end of 2015, the National Assembly adopted a set of laws that entirely abolished austerity measures relating to cash social assistance and partly discontinued those relating to child benefits and state scholarships. Furthermore, in 2015, Slovenia faced massive influx of migrants, most of them in transit towards the north. Since mid-October 2015, around 480,000 migrants crossed the country. Slovenia is doing its best, in cooperation with European partners and countries in the region, to find proper solutions for the management of this extraordinary migratory situation. Our country will continue to do its best with the support of volunteers, NGOs and international actors to provide them with the necessary care and medical assistance. Slovenia will strive to take appropriate care of migrants and international protection applicants in accordance with international standards and in collaboration with other countries along the Western Balkan migration route and will continue to grant international protection to all those entitled. In December 2014, Slovenia ratified the Council of Europe's Convention on Preventing and Combating Violence Against Women and Domestic Violence, which is an important step towards a more holistic and efficient response to violence against women. Several amendments of legislation adopted in this period further enhance the protection of rights pursuant to the International Covenant on Civil and Political Rights. With the amended Criminal Code, which took effect in October 2015, Slovenia has introduced a series of provisions that improve the protection of victims of criminal offences. Allow me to point out some of them. The criminal offense of threat, which used to be liable to private prosecution, is now prosecuted ex officio by a state prosecutor on the victim's request. A new measure has been introduced to protect victims, namely the restraining order imposed by the court for specific criminal offenses where the perpetrator has violated the physical or mental integrity of the victim. Another important amendment is the new criminal offense relating to the confiscation or destruction of personal documents in the context of criminal offenses of human trafficking. I would also like to stress the introduction of the new criminal offense of forced marriage or other marriage-like union. Following a recommendation of the Committee on the Rights of the Child, a survey was conducted in 2013 to examine the incidence of early and forced marriages among Roma community in Slovenia. It showed that the occurrence of child and forced marriages in our country was not negligible. Based on the survey and following the ratification of the Istanbul Convention, a definition of this new criminal offense has been prepared. In 2016, the issue of forced marriages will be included as a training topic for the staff of Slovenian social services. The amended code also defines the criminal offense of stalking, which includes harassment via electronic communications. Finally, the amended criminal code stipulates criteria for partial exclusion of liability relating to the criminal offense of disclosure of classified information in light of prevailing public interest and protection of the freedom of expression. Among others, this amendment protects journalists who reveal irregularities committed by the authorities. The amended Prison System Act, which came into effect in this January, guarantees the efficiency of legal remedies of convicted persons in the event of overcrowding in prisons. Based on the jurisprudence of the European Court of Human Rights and the conclusions of the Human Rights Ombudsman, prisoners claiming that they have been subjected to torture or other cruel forms of inhuman or degrading treatment are guaranteed more efficient legal protection, namely a rapid response to the alleged poor prison conditions. At the same time, the amended Act special attention is devoted to vulnerable groups, especially unaccompanied minors. Persons granted international protections may apply for family reunion and other forms of integration assistance. In 2015, Slovenia updated its standard operating procedure in cases of sexual and gender-related violence among international protection applicants and performed a series of multidisciplinary trainings, including topics from family law, social work, psychology, children's rights and duties, protection of human rights and fundamental freedoms, and asylum legislation. In March, a new law was adopted regulating international protection through a clearer definition of specific safeguards for applicants with special needs. It specifies the procedure to identify possible special needs of applicants for international protection and the elements necessary to ascertain the best interest of children. Furthermore, it introduces certain new procedural measures, particularly in order to enable rapid and efficient decision-making and prevent abuse of international protection without neglecting the fundamental procedural safeguards for international protection applicants. Slovenia guarantees every person equal exercise of the freedom of religion. Positive measures introduced by the state in this regard include efforts to ensure tolerance and non-discrimination, appropriate legal personality, and spiritual care in difficult circumstances. In 2015, on the initiative of religious communities, the government established the Council for Dialogue on Freedom of Religion. In addition to the representatives of the 4 principal communities, the Council also comprises 2 elected representatives of minor religious communities, an expert on non-discrimination, the advocate of the principle of equality, and the human rights ombudsman. In recent months, we have noticed, primarily on the internet, a rise in hate speech directed especially towards Islamic believers and their community. Moreover, several hostile acts targeting the premises of the Islamic community were reported and are now being investigated by the police. In the same period, the highest state representatives have publicly stressed that hate speech is unacceptable, condemned the hostile acts, and called for tolerance and mutual respect. On February 16, the competent parliamentary committee had a debate on hate speech. Its members condemned hate speech and called upon the government to examine the need to amend the relevant legislation and upon the competent authorities, primarily the police and the state prosecutor, to appropriately respond to hate speech. In Slovenia, Roma community enjoy all citizenship rights as well as special rights deriving from the laws based on Article 65 of the Constitution. Like all Slovenian citizens, Roma in all municipalities have the right to vote and be elected as members of municipal councils. In the municipalities where they have been traditionally present, they also have the special right to a Roma representative on the municipal council. The only special right stemming from the autochthonous status is the right for of those municipalities that have historically been settled by Roma. Based on the constitutional definition of municipalities as self-governing local communities, the legislator has linked the political representation of the Roma community on municipal councils to a continued or, in other words, traditional or historic settlement of such communities in certain municipalities. Mr. Chairman, by way of conclusion, allow me to present the activities of the Republic of Slovenia aimed at the dissemination of information relating to the Covenant and the concluding observation of your esteemed committee. In 2008, on the occasion of the 60th anniversary of the adoption of the Universal Declaration of Human Rights, Slovenia published a collection of all human rights-related UN treaties translated into Slovene. The publication included all Slovenia's reports pursuant to the treaties and the translations of the concluding observations by relevant treaty bodies. An electronic version is accessible on the internet, while book editions were distributed to all Slovenian public libraries and the Administrative Academy, the institution providing courses, trainings, and seminars for civil servants. Moreover, Slovenia continuously strives to raise awareness of international legal instruments relating to human rights. In December 2014, a volume was published on the occasion of the 25th anniversary of the Convention on the Rights of the Child. In addition to articles covering various aspects of children's rights, the publication comprises Slovene translations of the Convention and the 3 optional protocols issued for the first time in their entirety. It is available in all public libraries across Slovenia and on the internet. The report my delegation is presenting today has been drawn up with contributions from a number of ministries and government bodies. I have to point out that civil society organizations in Slovenia were informed about its drafting and thus had the possibility to participate with their opinions, comments, and proposals. Ahead of its adoption by the Slovenian government, the 3rd periodic report was also reviewed by the Interministerial Commission on Human Rights, comprising representatives of all ministries, NGOs, and the academia. Upon its submission, the report was published on the internet, where a Slovene translation of the concluding observations will also be made. In this year, the representatives of civil society organizations were informed of the dates of the consideration of the 3rd periodic report by the Human Rights Committee. Mr. Chairman, in 2016, we are celebrating the 50th anniversary of the adoption of 2 fundamental human rights covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. At the end, I would like to point out that Slovenia remains committed to promoting and protecting the rights ensuing from the 2 covenants. Furthermore, as a UN Human Rights Council member, a fortnight ago, our country called for their universal ratification. I look forward to a frank and constructive exchange of the accomplished progress and further challenges in the implementation of civil and political rights in Slovenia. Thank you very much for your attention. Thank you.
Muchas gracias, Su Excelencia.
Thank you very, very much, Your Excellency, for your presentation, your introductory statement. So I now turn to my colleagues of the committee for them to put their own questions or to voice concerns, give you feedback on what they have heard and what they have read pertaining to the 3rd periodic review of Slovenia. So without further ado, may I turn to Ms. Ivana Jelic for her to kick us off. You have the floor.
Thank you, Mr. President, and good afternoon to everybody. I would like to warmly welcome distinguished delegation of Slovenia, led by Her Excellency Madam Tina Brecelj, and to thank to the state for the replies and for the report. I would also like to thank this numerous delegation, well balanced in gender aspect, I would say, and highly qualified for being with us here. And thank you for your comprehensive opening statement, which actually already replied to some of my questions, to some of the questions that I prepared based on the report and your replies. Slovenia submitted its third periodic report in July 2014, as you said, 4 years after the state party is due. And thank you for addressing this issue and for explanation of reasons. State replied to the list of issues in time. And also concerning report, I would like to say that it's detailed, and we are thankful for all these details that you shared with us. Also, it is really great that you raised some issues of contemporary concerns of Slovenia, but also of the committee. And thank you for staying committed to fulfillment of your obligations under the covenant. Since we received your replies on list of issues, there were some new circumstances which actually became challenges for Slovenia, as I said, and many other European states, of course, but also high concerns of this committee. And here I mean primarily on refugee and migrant crisis, which needs urgent and accurate measures. The committee is aware of all measures that Slovenia has undertaken since autumn 2015 in order to adequately address the issue. I would like to commend cooperation of Slovenia with UNHCR and NGOs in regard to joint monitoring of EU external border practices in order to ensure respect of non-refoulement principle. However, it is of our concern, as well as of concern of High Commissioner for Human Rights, that Slovenia also undertaken some steps in regard of addressing refugee and migrant crisis, primarily the agreement among 5 states, among one Slovenia, is contracting party concerning security measures that could have negative effects to the rights of persons belonging to refugee and migrants in Southern and Central Europe, especially in terms of security measures adopted. Slovenia decided to close its borders with Croatia for migrants without valid visas of the European Union, and will no longer accept refugees who arrive by train organized. That was published on 9th March in 2016 as a statement of Prime Minister of Slovenia. And of course, it is a consequence of about 480,000 refugees that have passed in trains through Slovenia since the so-called Balkan refugee route was extended to Slovenia. It is great to hear that Slovenia is going to stay committed to its obligations in regard to respect of the rights of persons affected by this crisis, and we believe that you are going to do it in an excellent manner. However, my colleagues and me today and tomorrow are going to discuss with you more in details about this issue, and also, of course, primarily on follow-up questions concerning the list of issues and the report. And in this respect, today I would like to discuss with you more concerning issues number 1, 2, and 7. As you stated in your opening statement, legal status of ICCPR in Slovenian legislation is at the level of internal source of law, directly enforceable, according to the Article 8 of the Constitution of Slovenia. That was commended by the committee in its concluding observations concerning Slovenian second periodic report. And also, it was commented that provisions of the covenant have been directly enforced by the Supreme and Constitutional Courts as part of domestic legal order of Slovenia. Thank you for your replies in this respect, and please, can you share with the committee the information concerning other courts, direct application of the provisions of ICCPR, if any? Concerning raising awareness of the covenant among judges, prosecutors, and lawyers, please, can you be more specific concerning your reply under point 5 of replies to the list of issues? Namely, can you strengthen the statement that Slovenian lawyers, state prosecutors, and judges are quite familiar with the covenant, with more information concerned? In addition, a part of the seminars of the right of a child in relation to family protection or trafficking in human beings, violence against women, and protection on victims. Have there been other training courses for judges and state prosecutors concerning the rights and freedoms protected by the covenant? In regard to the new situation concerning refugee and migrant crisis, what measures in dissemination and awareness raising of the covenant, if any, have been undertaken among judges, prosecutors, police, army, and lawyers to address the rights from the covenant that could be additionally violated due to someone's status of refugee, asylum seeker, or a migrant? Having in mind that the cooperation with NGOs and civil society is important for improvement of human rights promotion and protection, please, can you update committee on the activities on promotion of the covenant that were jointly undertaken with the NGO, civil society, and academia? You mentioned your activities in this regard, but please, if you can elaborate on cooperation with civil society in this respect, that would be also important. Concerning issue number 2, from the replies of the list of issues, as well as from the report and additional information that committee received from civil society, it is obvious that Slovenian path towards establishing a national institution for the protection of human rights in accordance with the Paris principles is a long one. Please correct me, but from your opening statement, I assume that now the decision is that the Ombudsman for Human Rights would be strengthened in regard to become such an institution. Thank you. Because we actually got a lot of information on dilemma if new institution would be established or the existing one would be posted in that regard. From the civil society report, it is visible that although there are several institutions for human rights, there are no fully efficient and independent institutions. Some of them, like the Council for Implementation of the Principle of Equal Treatment, practically does not function. And on the other side, some of them do not meet regularly, or their organs do not meet regularly. So it is good that all angles, like all sides, government, ombudsman, NGOs, agree upon the fact that an efficient human rights institution is important to be established now. So if you can a little bit elaborate more on this, it would be useful. Concerning the effectiveness and independence of human rights ombudsman, it is important that such an institution have sufficient financial and human resources. And it seems that the budgetary cuts struck this institution during a couple of last years very much. So please, can you share with us the information on what measures were undertaken in order to ensure that the Ombudsman has the resources that are needed for its effective functioning? In addition, the Ombudsman has also the competence of national preventive mechanism under the OPCAT as of 2015. And as of 2015, there is a special unit within Ombudsman structure in charge of that task. So please, can you update the committee of the decision concerning dilemma should the unit stay within Ombudsman institution structure as it was during 2015, or there should be a separate unit to be established, and if so, when? This decision, as far as I understood, reading all the documents available, this decision depended on the National Assembly and the new state budget adopted at the end of 2015. So if you can update committee on that, this would be also useful. And finally, issue number 7, I'm trying to not to waste so much time in order to leave time to my colleagues as well. Concerning discrimination of Roma, I would like sincerely to thank you for sharing with the committee your own concerns and for an open approach to this issue, stating that the progress is slow and that there are steady advances in all aspects of national program for measures for Roma for the period of 2010-2015. And also thank you for stating that social inclusion of members of Roma community is poor and that government is aware of that. Social inclusion of Roma is complex and long-term process indeed, and we are all aware of that. And especially because of that, the state has additional obligation concerning positive, affirmative action measures. Thank you for describing in details in the state report and also in replies, but especially in the state report concerning measures undertaken in respect of education, employment, healthcare, poverty reduction and social inclusion, housing, living conditions, and measures to combat discrimination against Roma. Please, can you give us more information concerning the following? At what stage is drafting of new comprehensive national program for the period 2016-2021, as it was reported as one of the state's priority? What measures have been undertaken in respect of combating intolerance and hate speech against Roma? Having in mind that Roma Community Council has shown as ineffective in practice, a part of plans for amending the Roma Community Act, what has been undertaken to address such an inefficiency? Have any affirmative action measure been conducted? And, for example, have any measures in terms of financial assistance also been conducted? Finally, the committee would appreciate if distinguished delegation provide information on any measures taken to prevent and combat discrimination against Roma community since submission of the replies to the list of issues, with special emphasis to Roma women. With this, I'm finishing my questions now and thanking the delegation for open and constructive dialogue and for comprehensive opening statement.
Muchas gracias.
Thank you very much, Ms. Jelic. I now give the floor to Mr. Rodriguez Recia. You have the floor, sir.
Muchas gracias, presidente.
Chair, thank you very much. And a good afternoon to you and to the balanced. 7% are women and 30% are. So, I want to address fundamental aspects of, in terms of quality and approach in your report. I have two issues to raise with you, issue 3 and issue 9. Issue 3 and issue 9. On issue number 3, first of all, I have a question to put to you, which the committee normally puts to states parties. And this issue has two parts. First of all, I would like to ask you about statistics on discrimination with or without violence. So discrimination and violence. Secondly, the strengthening of the role of the ombudsman on the fight against discrimination. Now, I heard the head of delegation answered, in fact, quite a few of my queries in addressing the issue of the ombudsperson on equality or the fight against discrimination. But I'm going to reformulate my questions or repeat these questions. You have a structure to combat and prevent and document what is being done to fight against discrimination in the country. And you have this figure called the ombudsperson or the defender or the principle of equality. In addition to that, you have an inspection service which depends on the ministries, and you have the judicial branch of government that has an investigative powers also. Now, we asked you questions on statistics, and your answers tell us only about the complaints that have been put to this ombudsperson or the defender of equality. So we would like to put the question to you once again to get more answers, to see if whether now or within the next 48 hours you can elaborate on those statistics we asked you about, so that you cover other areas of investigation, such as the investigations carried out by the judicial branch of government or your inspection services, not just what the defender, the ombudsperson, has come up with. Another concern of ours is the following. When you describe the powers of the ombudsperson or the defender of the principle of equality, your explanations don't really help us enough, because we don't. You tell us about the fact that the ombudsperson is not very effective, and that its main job is to support victims rather than doing anything else. So the conclusion we draw is that whatever the ombudsperson says or the advice he or she gives isn't really received enthusiastically by the citizens. Then you speak to us about a law for the protection of people against discrimination, and you tell us that this law is being studied and it will come before the National Assembly or the Parliament in April. This is a draft law. And through this law, equality will be strengthened. Now, I've studied this draft law and I have some additional concerns to share with you. So we have this bill is dated from February, and I have some questions on them. And I would like to first look at the structure thereof. The state seems to be lacking strategy and lacking leadership in coordinating its anti-discrimination policies. To give you an example, you need affirmative action plans to defend the rights of victims of discrimination. For example, it would appear that you have guarantees on paper but not in practice. You also need more powers of complaints in the civil and administrative area and in the criminal area also. You have a complicated complaints mechanism. It's not user-friendly for victims, and the reparations or the remedies are not effective. And also the citizens are not really, they're not told enough about this particular area. There are not enough resources to create an anti-discrimination framework, because public and private sectors violate the rights of the citizens, and there's no clear consequences for the perpetrators of this discrimination. There's a lack of enforceability also of the recommendation of the ombudsperson and the defender of the defender I was describing earlier on, and these weaknesses were acknowledged also by the state before the Committee for Economic, Social and Cultural Rights. So my question to the state right now is can you give us more statistics broken down over the last few years as to the number of judicial cases or proceedings that have been brought on grounds of discrimination? But could you break these statistics down by outcome, conviction, by reparations that were awarded by courts and effectively awarded to victims. Also, could you clarify the following, or give us more information about the following? Because your report speaks of cases of discrimination. You say that there is a lack of transparency in the protection mechanisms in the context of this law I have been describing. Now, the European Commission Against Racism and Intolerance also looked at this figure of the defender of the rights, people's rights against discrimination, and it would appear that this figure is only one person who works for the Ministry of Family Affairs and who doesn't have a staff. And also CEDAW, the Committee for the Elimination of Discrimination Against Women, CEDAW, was also concerned about this. And their concern was that this bill, which is about to go before Parliament, could give, well, needs to give more quality and effectiveness to the issue of protection of citizens against discrimination. There's another aspect of discrimination I'd like to raise. It's an additional concern. And I would like to here raise the issue of asylum seekers. Can the state tell us whether in the first phase, when asylum seekers actually submit their claim for asylum, during the first phase, have the asylum seekers lost some of their protection, judicial protection? In other words, the law on international protection, which is in tune with Article 3 and 26 of the ICCPR and in tune with General Comment number 15 of the committee, could this afford more free protection in the first phase to asylum seekers when they submit their claim for asylum? What is the state doing also to prevent and cases of torture and to train officials? You tell us in your report that you are lacking resources to gather statistics before 2014. So my question to you is this: when the state says to us that you do not have reliable statistics on torture, what do you mean exactly? Do you mean that you have no cases of torture, or do you mean that you have no ability to gather data on cruel, inhuman, degrading treatment and torture? And what is the ability, what are your powers to verify, document these alleged complaints? Might it be, or could you possibly, could you tell us about what you've been trying to do to gather statistics about alleged cases of torture? Now, it's very positive for us to see that the CPT, that's the European Convention for the Prevention of Committee for the Prevention of Torture, visited your country. And it carried out visits, etc., investigated torture in Slovenia. So that really, to a great extent, assuages our fears as to what you are doing, and it reassures us that you are training your police force. But it would appear that your training of your police forces focuses more on how to use force and how the police officers can defend themselves. So what other aspects of the training of the police have you developed to prevent torture in the context of this very important work that the state is doing? These were my questions so far, Mr. Chairman. Thank you very much.
Muchas gracias, señor.
Thank you very much, Mr. Rodriguez, rather. I will now give the floor to Mr. Benachor. You have the floor, sir.
Merci, Monsieur le Président.
Thank you, Chair. First of all, I would like to speak to the delegation as a whole. I would like to wish the delegation of Slovenia a very warm welcome to the Human Rights Committee, and I would also like to thank the head of delegation for her report. I really find that it summarizes well, and I also found answers to the questions that I was going to ask. I am responsible for discussing with you two issues this afternoon, issues 4 and 5. Issue 4 relates to the application of Article 297 of the Slovenian Criminal Code, and issue 5 relates to female representation in public affairs, as well as in the private sector. So I will start with issue 4, the first that concerns me. In your list of issues, we asked you to give us statistics for the last 5 years regarding the number of complaints received by relevant authorities in relation to Article 297 of the Criminal Code. We also looked at investigations carried out, the decisions that, or rather the sentences passed by the courts. I'm going to look at this issue from 3 different points of view. First of all, the legal tools that regulate this, particularly criminal law in Slovenia, and then after that I will make comments on the statistics that you have presented to us, and then I will ask the opinion of the delegation on how certain forms of xenophobia have developed in Slovenia. So let me start at the beginning. The rule of law. The rule of law in Slovenia is characterized by this missing Article 297 in the Criminal Code, which says that incitation to discrimination or hatred based on religion or race, etc., or provocation to religious or racial hatred are anti-constitutional behaviours. That is a summary of the Constitution's article in this regard. By applying this article, the criminal law comes into play in order to apply Article 63. And that's where we come to Article 297, which looks at expression of hate, violence, intolerance, with regards to certain specific groups which are protected or members of such groups. So, Article 297 forms a part of this umbrella structure of legal tools which forbid intolerance and discrimination or incitation to these. However, Article 297 is not the only article of the legal system which forbids hate speech. As you said in your responses, but also in the State Party's report, hate speech is also forbidden by media legislation. And this is very important to note. Legislation relating to the media bans hate speech. Nevertheless, there is also Article 20 of the Public Order Act, where it says that incitation to intolerance is a crime. And then there's also the fact that in Slovenia there is surveillance of illegal content on the internet. So there's the WebEye project in Slovenia, which I believe is important, which allows people to anonymously highlight hate speech or incitation to hatred published on the internet. You have said that this tool has proven to be effective, an effective way of controlling hate speech, which, of course, is very common online. So I believe that in terms of legislation and protection mechanisms in place, there has been a great effort on the part of the Republic of Slovenia in this respect. The second part of what I wanted to say is statistics that we asked you to present. You gave us a table under Article 16 of the responses to the list of questions. So we have this table in response to the questions that were asked, and This comes under Article 16 of the responses to the list of issues which was sent to you by the committee. I would like to make a few comments on this. First and foremost, here I would ask the delegation to provide explanations on these statistics, because this table looks at figures which involve both the application of 131 and 297 of the new criminal code, as well as Articles 141 and 300 of the criminal code. I believe by that you're referring to the former criminal code. You add that Slovenia does not have any available data on the number of incriminations regarding hate speech or intolerance by public officials. So this leads me to my questions. First of all, why do you not have any data or statistics on the number of crimes committed within the civil service? Second question, still regarding statistics, could you give some explanation as regards this table, which I believe is not particularly clear and is not exhaustive? The third prong of my questions on issue 4, and this is a question that I would ask to the delegation. I would like to know what the delegation thinks of the statements that were given to us by some NGOs saying that following the serious terrorist attacks all over Europe, particularly last year in 2015, but also following the migration crisis, in Slovenia there is currently an unprecedented rise in xenophobia and Islamophobia, both in the media and on social networks, and even within the political sphere. If this should be the case, what is the government's attitude in order to put an end to this re-emergence of this phenomenon? After having listened to the head of delegation, I believe that you are aware of the problem. The government does not deny it. Indeed, there is a problem. So what I would like to ask is, what is the government doing in order to overcome or deal with this re-emergence of this type of behavior? Secondly, question 5. We asked you to provide statistics on female representation in public affairs, as well as in female presence in management positions, or rather decision-making positions in the private sector. The state's responses have two main pillars. The first pillar regards concrete achievements. What has been achieved in terms of female representation? The head of delegation indeed spoke of this issue, and what you said in your statement is perfectly in line with what we find in the State Party's report, particularly in the responses of the State Party to the list of issues. So there have been achievements, but on the other hand, we have the second pillar of government action in this regard, which is action to improve female representation, particularly in the private sector. In terms of achievements, I believe that, as you highlighted, Your Excellency, in your statement, there has been a clear improvement. It's absolutely obvious when you look at the figures. Female representation has been improved by the quota system. Slovenia uses a quota system, and I believe that you chose a good strategy because the results are before our very eyes. Introducing quotas has considerably increased female representation in parliamentary assemblies, in the National Assembly, as you said in your statement. 35.6% of deputies is a good achievement indeed, in the government as well. we also have an increased percentage of female representation because it went from 41.2% to 47.6%. So there as well, we have a noteworthy effect. And we also see the same with municipal councillors. It's not only on the national level, because according to the figures that we have received, municipal councillors also increase female representation within municipal councils, and even for mayors. There has been an increase there too, because we have moved from 5% in 2010 to 7.5% in 2014. To give the bare bones of what we need to know, I would like to say that this has been a remarkable improvement within the judicial system. I will be brief, I don't want to speak for too long, so I will give you 3 figures, and I will also give them to my colleagues on the committee. Of all of the courts, out of 940 judges, there are 250 male judges, which is 21.8%, and women represent 735, which is more than 78%. In terms of local courts, of 431, we have 72 men, which is 16.7%, and 359 women, which is 83.3%. And then, finally, in terms of prosecutors and general lawyers, of a total of 193 judges, we have 134 women and 59 men. So, what I would like to ask is that not only has there been a clear improvement of female representation within the judicial body in Slovenia, but as Mr. Rodriguez Recia was saying, my colleague, a minute ago, we seem to have the exact opposite problem now. We are going to have men asking to have quotas, particularly in the judicial body. If I were a judge in Slovenia, I think I would be rather concerned. I think I would be asking for a fair division of the judicial body between men and women. So, there are the achievements. I believe in this respect, for Slovenia, we can say that in terms of female representation in public office, in the government, in assembly, and in the judicial body particularly, we can take them as an example. But you have recognized that there is a gap in the National Council, where the representation of women is rather low. In the private sector, and here I'm coming to the second part of my statement on question 5, you recognize that female representation is still not as high as you would like. In the periodic report by the State Party, in the state's responses to the list of issues, you give us figures and statistics, and indeed, they're not really in women's favor, because in terms of business leaders, female representation only stands at 5%. But you are aware of the problem, it must be said, and you have started to act upon this. I believe in paragraph 21 of your responses, you say that the National Assembly hosted a joint session which brought together a series of ministries, of NGOs, and of committees. And you say that this meeting at the National Assembly led to a decision which meant that the Ministry of Labour, Family, Social Affairs and Equality Opportunities they were given the task of drafting a bill in order to introduce quotas in order to improve the representation of women in top executive management in the private sector. So you are making an effort here. You're aware of the problem in the private sector, but you have an action program to improve the situation. Thus, my question is, although the program was adopted last year, so it's only last year in 2015, it hasn't been going for very long, do you already have an idea of the first outcomes of these efforts to improve female representation in the private sector, particularly in executive management? That is all, Chair, for questions 4 and 5. I will have other questions, but I will save those for either later on or tomorrow, depending on how fast we work. Thank you, Chair, and thank you to the delegation and the head of delegation for the information that you have provided us with. Thank you.
Muchas gracias.
Thank you very much. So I will now give the floor to my colleague, Ms. Cyberford. You have the floor.
Thank you very much, Mr. Chairman, and I would like to join my colleagues in extending a very warm welcome to the distinguished delegation from Slovenia. I look forward to engaging in constructive dialogue with the delegation over the course of the next 24 hours. Now, my issues today concern issues number 6 and issue number 8. I would like to inquire first about the status of the so-called erased. These are persons whose names were deleted from the register of permanent residents. These persons who have been nationals of the Socialist Federal Republic of Yugoslavia and of one of its republic other than Slovenia lost permanent resident status in 1992, and their names were all erased from the register of permanent residents because they had not applied for Slovenian citizenship before the deadline, which was the 25th of December of 1991. As a result of this legislation, these persons became aliens or stateless persons illegally residing in Slovenia, and their status was unregulated for almost a decade. The distinguished head of delegation acknowledged in her opening speech that the state party responded very slowly to this mass violation of human rights. And I would like to recall that the erasure had serious consequences on the private lives of those who had been affected. Their papers were taken away from them. Some of them were evicted from their apartments. They could not work or travel. They lost their personal possessions and lived for years in poor conditions with serious consequences for their health. Others were even expelled from Slovenia. We thank the delegation for the statistical data provided in its answers to our list of issues. It appears from these figures that roughly 13,000 persons are still affected by the erasure. It also appears that even the act which sought to remedy the erasure provided for a cutoff date for the restoration of the resident status. Is it right that over 13,000 of the erased have not been able to restore their permanent residence status in the state party? I would also like to know, is it right that as of now, many of those affected by the erasure have no legal avenues for restoring their permanent residence status since the expiration of the July 2013 deadline, which was established in the 2010 law? I would like to recall that it was the deadline in the original bill which had led to the current situation in the first place. Nevertheless, the amended Legal Status Act again provided for a deadline for filing requests for permanent residence permits, which is expired then on the 24th of July 2013. I would like to know, why should it be necessary to introduce a 3-year deadline to remedy a violation of the Covenant on Civil and Political Rights? You have referred to the 2013 compensation scheme in your opening speech. I would like to know, to what extent do persons who have not yet regulated their status, which is roughly about 50%, benefit from the compensation measures under the 2013 Act regulating compensation for damage to persons erased from the Permanent Population Register, which is the Compensation Act. Is it right that compensation claims have been dismissed by courts for the failure to comply with these time limits? Finally, I would like, with your permission, Chairperson, to make a more general observation. The state party seems to suggest that by adopting the compensation scheme in 2013, it has fully and fulfilled its obligations to remedy the violations in the first place. I would like to recall, however, that in order to remedy a violation of the covenant, states should provide for restitution in integrum to the extent possible. So I would think that in order to remedy the erasure, the previous status needs to be reinstated upon request without any kind of deadline, irrespective of any kind of financial compensation, which would then add on to the reinstatement. Now, with your permission, Chair, I would like to turn to issue number 8, which concerns violence against women. Again, I thank the State Party for the answers. We recognize the measures taken to raise awareness and education to prevent domestic violence, and the distinguished head of delegation referred repeatedly in her opening speech to this issue. So I take it that you are very much aware of this issue, and I look forward to engaging in more detailed discussion about the measures taken. Despite the implementation of the National Program of Family Violence Prevention, which was effective from 2009 to 2014, the Committee on Economic, Social and Cultural Rights expressed concern in late 2014 about the high prevalence of domestic violence in the State Party. The statistics on domestic violence, which the State Party submitted to us, indicate that there has been a 50% rise in the number of domestic violence cases between 2010 and 2015. Furthermore, there is the concern that spousal abuse may be generally underreported, so there is a substantial number of cases which are not included in the statistics. I would like to know what has been the outcome of the 2009 to 2014 national program. Has its effectiveness been subjected to examination? Where does the State Party see further need for action? The distinguished head of delegation referred in her opening speech to a public consultation which took place in February. I'm not quite sure whether the amendments that you have been referring to with respect to the Domestic Violence Prevention Act have already been adopted. I wasn't able to understand the sentence, and I would like to know what are the changes which have been adopted or which are envisaged. I also wonder whether there is a new national program for the prevention of family violence. It appears that there have been a lot of activities in the previous program, and I would like to know whether there's a follow-up. It seems that there is no permanent mechanism to coordinate, monitor, and assess the effectiveness of the measures taken to tackle the violence against women. How does the State Party ensure that assistance is accessible also to Roma women, to migrant women, to women with disabilities or older women? Finally, I would like to inquire about the effectiveness of protection mechanisms for victims of domestic violence. We have received information indicating that restraining orders issued against alleged perpetrators are insufficiently enforced, and I would appreciate to receive more information about the enforcement of these restraining orders. That brings me to the end of my questions for today. Thank you, Mr. Chairperson.
Muchas gracias.
Thank you very much, Ms. Seibert-Four. I now give the floor to Mr. Olivier de Frouville.
Tiene la palabra, señor.
Chair, thank you very much. I also wanted to extend a warm welcome to the delegation of Slovenia here this afternoon and thank the head of delegation for her excellent, comprehensive introduction, which indeed does shed much light on matters we were concerned about. I am going to focus on issue number 10, namely trafficking in persons, people trafficking. First of all, I'd like to thank the State Party for all the responses we've had from Slovenia on this matter. That is in your responses or replies to our list of issues. So from the outset, I think we can really commend the State Party for all the efforts the State Party has made over the last few years, be it with providing care for victims of trafficking or the prevention of this phenomenon of trafficking. Training is given to law enforcement personnel. That's very commendable, and that is to identify victims of trafficking, and in particular when these people are migrants. It's also very commendable that emergency shelter is provided for victims of trafficking, and also temporary residence permits are granted to victims of trafficking when they are aliens. So these are clear signs that the State Party is taking this matter seriously and is taking laudable measures to provide care to the victims. Of course, there are aspects thereof that can be improved, and I am looking forward to us having an exchange of views with you on how we can improve things. In our list of issues, which we sent to you, we asked whether it might be desirable to set up more of a formal method to identify victims of trafficking. In your replies, you tell us that the procedure had not yet become a formal one. You told us that you had a well-identified procedure, namely when the law enforcement personnel finds a case of trafficking, it reports it to the office of the prosecutor. So there is a system. Do you not think, however, that it might be useful to further formalize this identification procedure? Now, if you haven't made it a formal procedure so far, why not? Do you not believe, or maybe you've concluded that there would be no added value in formalizing this procedure? Furthermore, do you not think it would be advisable to adopt more of a comprehensive law on trafficking that would give a proper framework to repress it or to suppress this phenomenon, as was recommended by our sister committee, the CEDAW, in their 2015 concluding observations? Finally, in your reply, or rather in your introductory statement, Madam Minister, you spoke about guidelines that were adopted this year, guidelines for identification, assistance and protection of victims of trafficking. I'm just curious, what do these guidelines cover? What purpose do they serve? And to what extent are they part of your systems to fight against trafficking and identify victims of trafficking? Of course, as Ms. Jelic, who took the floor first this afternoon, we are going to discuss this afternoon and tomorrow today's context in which thousands of migrants seek to go through Slovenia, and we're going to speak about the impact that mass migration might have on the measures the State Party has taken so far to control migration. Do you not believe, in this context, your procedure to assist and to identify victims, is it as effective, efficient as it was before? That's my question to you. According to what we've heard, trafficking victims who come to your borders cannot avail themselves of the protection mechanism. They're not entitled to it. Now, you can tell us, of course, if migrants are not allowed to go through Slovenia at all, of course they're not entitled to the protection. But could you tell us more about this? What impact is the current situation having on the operation of your mechanisms to identify victims of trafficking? And have you sought to overcome the obstacles that stood in the way of migrants availing themselves of your care services? Moving on now to providing shelter or care for victims of trafficking. In our, or underlying our issue, in our list of issues sent to you, was this concern, the concern that shelter provided for victims of trafficking might be conditional, especially following the 30-day emergency shelter provided for victims of trafficking. What happens after that, those 30 days? Now, from what we understand, victims of trafficking are entitled to 30 days. And of course, these 30 days are very important to protect the victims of trafficking from the grasp of the trafficking networks. Now, we believe that for a victim to be entitled to further shelter after the 30 days, they need to cooperate with the judicial system. So can you tell us whether that is true or not? Must a trafficking victim consent to cooperate with the justice system in order to be entitled to extended shelter beyond those 30 days and to be entitled to the care and support that goes hand in hand with this shelter? Furthermore, could you shed some light on the following for me? Could you tell us about the difference between the regime applicable to the victims who have Slovenian nationality and the regime that is applicable to aliens? I've understood that you have two legal regimes, two legal provisions, texts that govern care provided for victims of trafficking, but I don't quite understand how they are different. What is the difference between those two legal regimes that provide differentiated care for Slovenian victims and alien victims of trafficking? Among the other concerns that we have heard, and I'm concluding with this concern, there was the concern of the recent, over the last few years, of the fact, the statistics tell us that fewer and fewer people are being prosecuted on charges of trafficking. Could you give us today some updated figures for the last 3 years, in fact, as to how many people have been prosecuted and convicted for trafficking in the country? Can you confirm also that there's been a drop in the number of prosecutions and or convictions? Because obviously they're not the same, because you might have many prosecutions but few convictions. There's a difference in the time frame as well. So could you tell us, the prosecutions and the convictions, have they indeed fallen? And if they have indeed fallen, if we're right, could you try and tell us why these figures have fallen in terms of prosecutions and convictions? Thank you very much, Mr. Chairman. Thank you very much, says Mr. Salvioli, the chair. I now give the floor to Mr. Politi. You have the floor, sir.
Chair, let me convey also my warm welcome to the delegation of Slovenia, so numerous and so well balanced. And I would like to congratulate also the head of delegation for her presentation. Colleagues have already covered a lot of territory, and I do not intend to get into the specific issues that they have already addressed. But I was interested in some of the elements given to us in the presentation by the head of delegation concerning the amended criminal code that took effect in October 2015, and on the points that are focused on protection of victims of criminal offenses. I would like to make 2 or 3 The first one concerns the criminal offense of threat. This is a positive development in the context of protection of victims, in particular women and children and minors. I'm interested in some clarification with regard to the lines where the head of delegation has said that the criminal offense of threat, we choose to be liable to private prosecution, is now prosecuted ex officio by a state prosecutor or on the victim's request. Now, I would like to know whether the victim's request is always required, or the prosecutor can prosecute this crime also on the basis of information that he has received from other sources. I would like to have this clarification because the concept is different. If the victim's request is always required, it may be doubtful whether that this kind of prosecution can be qualified as ex officio. Perhaps the delegation can clarify this point. The second point concerns the introduction of the new criminal offense of forced marriage or other marriage-like union, and the incidence of early and forced marriages among Roma community in Slovenia. There is a reference to a survey that was conducted in 2013, and I would be interested to know whether there are specific statistics of these incidents of early and forced marriage among Roma community in Slovenia. I apologize in advance. Maybe this information are already contained in the report. I went through the report. I couldn't find them, but as I said, I may be wrong. But it would be interesting to find out exactly what is the incidence in terms of numbers of these types of early and forced marriages. And the third point concerns the offense of stalking. It is said that this offense includes harassment via electronic communications. I imagine that also that the definition of the crime of stalking in Slovenian legislation today includes a series of elements, of examples, of types, of means through which the stalking is effected. This is not the way that all legislations go in addressing the crime of stalking. Sometimes there is just a general definition of acts of persecution. I'm not saying that one is better than the other, but I'd be interested to know whether there is a list of examples of cases, of means through which stalking can be committed. And again, is it can be prosecuted, this crime of stalking, at the victim's request or always, or is there any possibility of an ex officio persecution, in particular when the victim is a minor, for example, or a disabled person? Thank you.
Muy bien, muchas gracias.
Very good. Thank you very much, Mr. Politi. Excellency, as you will have seen, my colleagues have many concerns. They've put many questions to you. So as I promised to you earlier on, we are going to give you some time to put together some answers. Looking at the clock, I can only give you 15 minutes. 15 minutes, so we can resume at 5 and begin the second part of our dialogue. So in your follow-up questions, colleagues, turning to colleagues, and what you ask tomorrow also, please be frugal with the time as much as possible so that we can work as effectively as possible. So we take a 15-minute break and resume at 5 sharp. Thank you.